Right, so we seem to have a stable number of participants, so we'll get started. Most of you know me. My name's Marc Brown. I head up the Insolvency and Restructuring team at St Philip's Chambers. And this morning, I'm giving another in our webinar series. Today, I'm talking about Brexit and insolvency, the Recast Regulation and Insolvency Proceedings. And this webinar was really instigated by the fact that I sought and obtained an administration order on the 5th of January of this year, so pretty much as early as you could be after the full impacts of Brexit, and faced with the question of what does one put in the order dealing with where we had previously dealt with the impact of the EU insolvency regulation. And most of us will be familiar with the standard wording that used to be included in orders to deal with the impact of the regulation. And so what do we do about that now? And so I thought it'd be useful to share with you all the impact of Brexit and most practically on the orders that we are used to obtaining. So this is only a short webinar on this topic. I know it's billed for 45 minutes, but it's unlikely to be that long because I'm most interested this morning in answering that key practical question for you. What do we do about those orders? So, first slide then. Chris Whitty style. Next slide, please. The end of the transition period on the 31st of December 2020 marked the UK's final departure from the European Union. And that gives rise to significant changes to cross-border insolvency proceedings. And that's the relevant date for those coming into effect. Most importantly, it affects the jurisdiction to open insolvency proceedings. And aside from opening those proceedings, the other important aspect is recognition of those proceedings. And that's proceedings in other member states being recognised here in the UK, and insolvency proceedings opened here in the UK being recognised in other member states. To analyse the effects of Brexit, we need to look at firstly the Recast Regulation, the EU regulation on insolvency proceedings, originally 2012, recast 2015, and what was the position before. After Brexit, what's changed? Where's the legislation now? Where do we look for it? And finally, and I think my key takeaway from today's webinar, the practical issues arising from that. So the Recast Regulation, which I'm sure many of you are familiar with, Insolvency Regulation EU 2015/848, the effect of the regulation was not to harmonise insolvency law amongst member states, but rather to govern jurisdiction between member states to open insolvency proceedings. And it governed which law relating to insolvency proceedings would apply, and it allowed for automatic recognition of those insolvency proceedings among the respective member states. And it was based on the fundamental concepts of main proceedings being opened in one member state, and that the main proceedings would be opened wherever the entity, whether that's corporate or individual, had its centre of main interests, or its COMI, as we refer to it, with the idea being that if one opened one main set of insolvency proceedings in one member state, which was the member state where that entity had its centre of main proceedings, that insolvency law would then govern the insolvency across the whole of the member states, therefore governing who had jurisdiction to open the insolvency proceedings, main insolvency proceedings, and then said what law would apply to it across those member states. It also provided for there to be secondary proceedings, and they would be proceedings where the centre of main interests of the entity was in a different member state, but the entity had an establishment in a different member state. And so you would have the main proceedings, and the law of where the main proceedings were would govern the insolvency proceedings. But if there was an establishment in another member state, you could open secondary proceedings there. And it also provided for the less commonly seen tertiary proceedings, proceedings in rem, where you were dealing with specific property. So the UK officially left the European Union on the 31st of January 2020. But for a period of 11 months thereafter, we were governed by the withdrawal agreement. And that gave rise to a transition period that took effect until the 31st of December 2020. During the period of the withdrawal agreement, the UK effectively still effectively functioned as a member state. So the EU regulations continued to apply in the UK. That importantly retains the effect of the recast regulation during the period of the withdrawal agreement. So if main proceedings were opened under the regulation in another member state, they continued to be automatically recognised in the UK as main proceedings during the withdrawal agreement. And similarly, if you applied to open insolvency proceedings during the period of the withdrawal agreement, then we would continue to see, does the insolvency regulation apply? Yes, it does. And is the debtor's centre of main interests here in the UK? If they do, then we open main proceedings under the regulation. So it was business as usual during the period of the withdrawal agreement. After that date, however, the 31st of December 2020, we're in a different situation. There was obviously a lot politically about the exit agreement that was negotiated right before Christmas in 2020. And nothing in that exit agreement deals with insolvency. Similarly to financial services, nothing dealing with insolvency. So as far as we were concerned, in the insolvency and restructuring sphere, it was a hard exit. There are transitional provisions that deal with what happens up to exit day, but they are essentially that the regulation will apply where the proceedings are opened up to the exit day. That's a phrase I'm going to come on to consider on the next slide. So if you've opened proceedings before exit day, then the regulation will continue to apply. And if proceedings were opened before exit day elsewhere, they will continue to be recognised in the UK afterwards, as I say, as long as the proceedings were opened before the exit day. Now, what had been prepared for in 2018 in relation to the UK's exit from the EU was the European Union Withdrawal Act 2018. Section 3 of that act transposes into UK domestic law direct EU legislation. So where there are regulations that have direct effect in the law of the United Kingdom, and the EU recast regulation is such a directly effective EU legislation, then it is to be treated as being transposed into domestic law. And that's the effect of Section 3. So EU legislation is imported into domestic law, subject to any amendments. Now, I pause there to deal with a rather tortuous bit of legislation that deals with when these come into effect. There is reference in much of the legislation to exit day in relation to commencement. It can throw one off guard when you look at the legislation and you see exit day and you try and find a definition of exit day because you won't find it. Because any reference to exit day in relation to coming into force is to be read as IP completion day. That's implementation completion day. And that's by virtue of the European Union Withdrawal Agreement Act 2020, Schedule 5, Paragraph 1. So wherever we see the words exit day, if it relates to coming into force, we must read that as IP completion day. And that's where we find the specific day, because Section 39 of the European Union Withdrawal Agreement Act 2020 says that IP completion day is 11 p.m. on the 31st of December 2020. So that's when various legislation amending the EU regulation, as it's now imported into domestic law, comes into effect 11 p.m. on the 31st of December 2020. After IP completion day, what's the position? Well, the jurisdiction to open insolvency proceedings in the UK may be under the regulation as it applies in the law of the United Kingdom if, firstly, the debtor's centre of main interests is in the UK, or the debtor's centre of main interests is in a member state with an establishment in the UK. So one can find jurisdiction in the UK to open insolvency proceedings if either of those two things applies. If they apply, then one can open insolvency proceedings under the jurisdiction of the regulation as it applies in the law of the United Kingdom. Now, prior to IP completion day, of course, the idea was that the recast regulation was the only source of jurisdiction to open insolvency proceedings, and that was the very basis of the regulation giving rise to a system of recognition across member states. But now that we are no longer a member of the European Union and therefore the regulation, this jurisdiction under the regulation is no longer the sole way of recognising jurisdiction to open insolvency proceedings. And it's expressly stated that the jurisdiction under the regulation as imported into domestic law is in addition to any existing grounds for jurisdiction that already apply in UK law. So if you want to open insolvency proceedings against an entity here, you can look at whether you have jurisdiction under the regulation as it applies in the law of the United Kingdom. You can look at whether the debtor's KME is in the UK. You can look at whether its KME is in another member state, but it has an establishment in the UK. But say, for instance, you can't identify either of those gateways to jurisdiction. Or say, for instance, that it is difficult or complicated to identify where the debtor's centre of main interests is, or difficult or complicated to identify whether the debtor has an establishment in the UK. Then what you might do instead is try and identify whether there are any other grounds for jurisdiction in the UK. One example might be that the company is registered in the UK. Now, registration in a particular state gives rise to a presumption that a company's centre of main interest is in that country. But that is displaceable by evidence. But you may seek to rely, for instance, upon that registration as giving rise to jurisdiction without recourse to where the debtor's centre of main interest is. Now, I only raise that as an example of how prior to IP completion day, we had a sole method of jurisdiction under the regulation. But now we have the regulation as imported into domestic law, giving rise to jurisdiction, but in addition to any existing grounds for jurisdiction that apply in UK law. So that's a brief overview of the recast regulation, and then what happens after 11 PM on the 31st of December 2020. But what I'm really concerned with this morning is a couple of practical issues. And to my mind, and this was what came up on the 5th of January, was what happens in respect of winding up orders, administration orders, and other orders that we are very used to seeing standard wording being used. And along the lines of, and upon the court being satisfied that the EU regulation applies and that these are main proceedings, etc. We have, by virtue of the Insolvency Amendment EU Exit Regulations 2019, new wording inserted into the Insolvency Act and the insolvency rules to give effect to the amendments to the recast regulation and the amendments to domestic law by virtue of IP completion day. And of course, right up to Christmas of 2020, we didn't know what the relationship with the EU was going to be like after IP completion day, and whether any agreement would include dealing with insolvency provisions. And as a result of that, you are likely to find, as I was, that most of the textbooks have not yet been updated to give effect to the amendments from the Insolvency Amendment EU Exit Regulations 2019, although I'm sure that's in the process of being done and in many cases has been done. But those amendment regulations amend things like the insolvency rules, which are quite specific in places as to what an order for various things, for example, an administration order should say. And it includes wording in relation to the applicability or otherwise of the EU regulation. So one's left with seeking to make amendments to those orders to give effect to the new regime. This is the wording in an administration order from His Honour Judge Cook in early January that was adopted, bearing in mind the points that I've been talking about. I'll read it out. Without prejudice to the court's jurisdiction under other provisions of the law of the United Kingdom, the court is satisfied that the EU regulation, as it has effect in the law of the United Kingdom, applies, and for the purposes of that regulation, the proceedings are Comey proceedings. That was a centre of main interests in the UK case. So what you'll see from the wording of that order is that the court was keen to ensure that the wording recognised the effect of the post-transition position, that the regulation gives rise to one method of jurisdiction, but it is expressly without prejudice to other provisions of the law of the United Kingdom that might give rise to jurisdiction. And that's why the initial wording is there, without prejudice to the court's jurisdiction under other provisions of the law of the United Kingdom. But the next sentence is the one that you'll become more familiar with. The EU regulation as it has effect in the law of the United Kingdom. And that's the phrase that the amendment regulations really bring to the fore, and that you'll be seeing more regularly in applications and orders of this type. The EU regulation as it has effect in the law of the United Kingdom. And that's to recognise the transposition of the recast regulation into domestic law, subject to the amendments that have been made. Now, subsequent to that, of course, Birmingham's not the only court dealing with this. I have become aware that Chief Insolvency and Companies Court Judge Briggs is currently using this wording, and upon the court being satisfied on the evidence that the EU regulation on insolvency proceedings, as retained by the European Union Withdrawal Agreement Act 2020 and amended by the Insolvency Amendment EU Exit Regulation 2019, applies. The company has its centre of main interest within the United Kingdom, and that these are Comey proceedings as defined by Rule 1.2 of the Insolvency England and Wales Rules 2016. So that's the wording being used by ICC Judge Briggs. Which one is better or right, perhaps not for me to say, but I do note that that wording does not include the magical phrase, the EU regulation as it has effect in the law of the United Kingdom, which is the one that is particularly used in the regulations. But given that that's the Chief Insolvency and Companies Court Judge, it may well be that that becomes the standard wording. Now, the various standard forms are in the process of being updated. I did have a look yesterday on the government's website and saw that the standard form administration application has been amended, and it refers to the EU regulation on insolvency proceedings as it has effect in the law of the United Kingdom, and reference to whether the proceedings are Comey proceedings or establishment proceedings. And that, I think, is something we will see over the next few months, to the extent that it's not happened already, that various standard forms and standard wording will be updated and will be adopted. And it's likely that this issue will not be an issue in a few months' time when we all have standard wording that we adopt, just as we did under the regulation. The other practical issue, it relates to that of recognition. And the position is that the UK is now a third country, not a member of the European Union, and not a member or directly involved in the regulation. And that means that insolvency proceedings opened after IP completion day will not be automatically recognised in member states. Insolvency practitioners will have to apply in other member states on a case-by-case basis for recognition of UK insolvency proceedings in other member states, applying the recognition provisions of the particular member state that they seek recognition in. And that's outward looking recognition in member states of insolvency proceedings here. Inwardly looking, recognising insolvency proceedings in other member states here in the UK will also have to be done under other provisions of UK law, and not automatically under the regulation. And so those seem to be the key practical issues, the orders that we're dealing with on a day-to-day basis, and recognition, which now must be done on a case-by-case basis. So there are no questions that I've been posed. I have received in advance a question as to a members' voluntary liquidation that was started prior to the IP completion day. So members' voluntary liquidation opened prior to 31st December 2020 that now seeks to convert to a creditors' voluntary liquidation after 31st of December 2020, and will the insolvency regulation apply? My answer to that is that the insolvency regulation did not apply to the MVL in any event, because it was not a liquidation based on insolvency. And so after the 31st of December 2020, the insolvency regulation does not apply. Rather, the regulation as it applies in the law of the United Kingdom will apply. And they are either COMI proceedings or establishment proceedings. And so I hope that answers that question. If I'm also asked the question, will the forms used for out-of-court appointments of administrators also require updating? Well, the answer to that is yes, insofar as they have not been already. Yes, those forms will need to be updated. They can no longer say that the EU regulation applies and these are main proceedings. They need to say that the EU regulation on insolvency proceedings, as it has effect in the law of the United Kingdom, will or will not apply, and that the proceedings will be COMI proceedings or establishment proceedings. So, as I say, my hope is that those documents are in the process of being updated if they've not been already, but you will need to have a look at the forms that you're using to see if they contain that wording. And as I say, the magic phrase that you want to look for is the EU regulation on insolvency proceedings as it has effect in the law of the United Kingdom, to make sure that that magic wording has been applied. That's my discussion of the EU regulation. Just having a look to see if anybody else has asked any other questions. Yes, I'm asked another question. What's the position on petitions commenced before December for hearing after 31st of December 2020? Well, the date of commencement of proceedings is dealt with under Article 2 of the EU regulation. And the general position is that the order takes effect. I know winding up relates back to the date of the petition, subject to the transitional provisions that we have at the moment. But in respect of, for instance, an administration order, the order is made and the proceedings are opened at that point. Where one has a petition, it's, as I say, slightly complicated by the temporary amendment to the relating back provisions under the Corporate Governance and Insolvency Act. So one will have to look at actually the specific date on which the petition was presented to see when the liquidation will in fact commence. If the insolvency proceedings are taken to be opened prior to 31st of December 2020, then the EU regulation will apply. If they are opened after 31st of December 2020, then the EU regulation, as it has effect in the law of the United Kingdom, will apply. So I'm sorry, that's a slightly complicated question, but it depends on, sorry, complicated answer. It depends on the application of Article 2 of the regulation, the date on which the petition is presented, and the impact of the Corporate Governance and Insolvency Act. Yeah. So I think that's all the questions. If anybody does have a question or would like to get in touch with me about this or any other issue, then please do get in touch with me or my clerks, and I'd be happy to chat these issues through with you. To let you know by way of advance warning, many of you will be aware that usually in around March of each year we have our insolvency conference. This year it's to be held online via a series of morning webinars much like this through a week, culminating with the end of the week with a live panel discussion of various issues that have arisen through the week. So please do look out for advertising and marketing on that issue when we will let you know what's coming up. Thank you, and thanks to those of you saying thank you. I'll end the webinar now. Thanks for joining me this morning. I look forward to seeing or speaking to you in due course. Goodbye.